Mom passed on a Tuesday. By Friday, her daughter was standing at the bank, death certificate in hand, heart still broken from the funeral arrangements, trying to pay the funeral home and keep the lights on at the family home. The teller looked her dead in the eyes and said the account was frozen. Not one single dollar could come out. The power company was already calling. The mortgage was still due at the end of the month. The family had to borrow money from relatives just to survive the first few weeks, while they were still planning the service and processing the grief. This wasn't some wealthy family in Charlotte. This happened to a regular, hard-working family right here in the Triad. People just like you and me. Here's exactly why this happens in North Carolina, what your family will go through step by step, and what you can do this week so it never happens to the people you love. Stay with me. Meet Linda from Louisville, just a short drive from Winston-Salem. Her mom had about $28,000 sitting in a checking account at one of the big banks right here in town. Only Mom's name was on the account. No joint owner, no payable on death beneficiary listed. It was the kind of simple setup most North Carolina families have because they never thought twice about it. When Linda got to the bank that Friday morning, death certificate in hand, she was already exhausted from making calls and handling the immediate aftermath. The teller looked at her and said, "I'm sorry, the account is frozen." They couldn't touch a single dime until the court officially appointed a personal representative. That process took weeks. In the meantime, the mortgage kept coming due, the power bill kept piling up with late notices, and the funeral home wanted several $1,000s up front before they would even schedule the service. Linda ended up borrowing from her sister just to keep the family going. Money she had to pay back later while still working her regular job and taking care of her own kids. The emotional weight was crushing. Linda told me later she felt completely helpless standing at that teller window, realizing that even though this was her mom's money her mom worked her whole life for, the bank wouldn't let her have any of it. This didn't happen because the family was irresponsible. It happened because they did exactly what most North Carolina families do. They assumed the money would just automatically go to the kids. No extra steps needed. That assumption cost them thousands. What the bank never told Linda, and what most families don't know until it's too late, is that the moment a bank finds out someone has died, they freeze any account that's only in that person's name. The money no longer belongs to the family. It legally belongs to the estate. The bank locks everything down immediately to protect themselves from lawsuits or mistakes. They're not trying to be difficult, it's just how the law works here in our state. Here's exactly what that process looks like in real life, step by step, because this is what Linda had to go through. She had to drive down to the clerk of Superior Court in Forsyth County with the death certificate. She filled out an application to become the personal representative of her mom's estate. She paid the filing fee, stood up and took an official oath in front of the clerk, and then waited, sometimes days, sometimes weeks, for the clerk to issue the official letters. Those letters are the only paperwork that proves to the bank she's legally allowed to handle the estate. Only after she had those letters in hand could she go back to the bank and finally access the account. That whole process easily takes weeks, sometimes months, depending on how busy the court is and how complete the paperwork is. Even for smaller amounts like Linda's $28,000, it's not instant. There is something called a small estate affidavit that can sometimes speed things up if total personal property is under roughly $20,000, or up to $30,000 if the surviving spouse is the only heir. But even that shortcut requires waiting at least 30 days after the death, filling out the right form, and getting it approved by the clerk. You can't just walk in the day after and use it. Joint accounts with right of survivorship usually work better, but only if they were set up correctly with that specific wording in the bank's written agreement. A lot of older joint accounts don't have that language, so they still end up in probate. The simplest fix most people never hear about? a payable on death, or POD, beneficiary. You just name the person or people you want the money to go to. When you pass, the bank hands it straight to them. No probate, no court, no waiting months. The money transfers directly by operation of law. A lot of families try to handle this themselves and end up making things worse. Some name the wrong person as POD beneficiary, like a minor child without naming a guardian, and the bank can't release the money without dragging the family back into court for more paperwork. Others think a simple joint account is enough, but if it wasn't set up with right of survivorship in the written agreement, it still goes through full probate and gets frozen. I've seen families wait too long to update beneficiaries after a divorce or after kids move away, and suddenly the wrong person is listed, or an ex-spouse is still on the account. And the biggest mistake I see over and over? Trying to pull money out or close the account before the bank gets the official paperwork. That can get you in serious legal trouble, delay everything even longer, and create new problems with the IRS or the court. Linda's family spent $3,200 and borrowed money they didn't have, all while grieving. That $3,200 wasn't one big bill. It was the filing fee at the clerk's office, attorney consultation fees, certified copies of the letters the bank required, and then all the late fees on the mortgage and utilities that kept stacking up because they couldn't pay them on time. Family tension rose. The stress on top of losing mom made everything harder. And this is exactly the kind of small problem that snowballs into the $200,000 probate disasters that end up costing families their house or their life savings. After everything she went through, here's what Linda did so her own kids will never face the same nightmare. You can do all of this before the end of this week. First, she pulled out every bank statement and every account she could find and checked whose name was actually on each one. She was shocked at how many were only in her mom's name. Then she went to the bank, or did it online where the bank allowed it, and added a payable on death beneficiary to every account. Completely free. Took about 10 to 15 minutes per account. She reviewed her own joint accounts to make sure they had right of survivorship clearly written on the signature card and agreement. And because she owns a house and has a little more saved up, she started looking at a revocable living trust. I made a full video on exactly how a trust protects your Winston-Salem home and keeps it completely out of probate court. It's the next video on this channel, and I'd watch it before the end of this week. Finally, she sat down with her family and had the open conversation. No more assumptions. She explained what she learned the hard way, so everyone was on the same page. Linda's family spent thousands and borrowed money they didn't have, all because of something that could have been fixed in one trip to the bank. One trip to your bank this week. Add a POD beneficiary to every account. That's it. Don't make Linda's family's mistake your family's story. If this hit home, drop a comment right now. Have you or someone close to you ever dealt with a frozen bank account after a death? What happened? And if this helped, hit subscribe, because the next video covers exactly how to transfer your Winston-Salem house to your kids tax-free and keep it completely out of probate. You don't want to miss it. This isn't about getting rich. It's about protecting what you already have for the people you love. Assets over excuses.